Hello, welcome everyone again. My name is Adriana Fernandez. I'm a regulated Canadian immigration consultant coming to you from Vancouver, British Columbia. And today, in this video, I'm going to talk about refusals of spousal open work permits derived from post-graduation work permit under Section 186. So if you have recently received a refusal on your spousal open work permit derived from a post-graduation work permit of your spouse under Section 186W, this applies to you. This is about maintained status, ability to work, and spousal open work permit eligibility. Let's remind everyone that the Canadian Charter of Rights only applies to citizens and permanent residents, but unfortunately does not apply to temporary residents. Unlike the natural justice and procedural fairness principle, which does apply to all, especially in immigration matters. So let's review the actual situation. The Section 186W of the Immigration and Refugee Protection Regulation states that a foreign national, again, you're either a foreigner or a national. You can't be both. This should be rephrased. I don't know who designed and who wrote this sentence of the regulation, but foreign national should be modified. A national term and foreign are opposite terms and they indicate different meanings. National is more related to a citizen, so this should say the Section 186W of the Immigration Refugee Protection Regulation states that a foreigner does not require a work permit if W. They are or were the holder of a study permit who has completed their study program or their program of study, and they apply for a work permit before the expiry of that study permit, and a decision has not yet been made in respect of their application. So if you are a holder of a study permit, have completed your study program, have applied for a post-graduation work permit altogether with your spousal open work permit before the expiry of your study permit, and the application for your spousal open work permit was refused under this section, there is a reconsideration option under the principle of natural justice and procedural fairness, which applies to immigration. First, right to be heard. Was the applicant given an opportunity to provide all relevant information or clarification regarding their eligibility under Section 186W? If not, this principle has been breached, enabling the option for review where the applicant can fully present their case, obviously with the assistance of a lawyer. Provision of reasons for decision. Was the refusal decision accompanied by clear, specific reasons? If the reasons provided were inadequate, or if no reasons were given, this could be a violation of natural justice, as the applicant would not understand the basis for the refusal or how to address it in an appeal or reconsideration. Bias and impartiality. Was the decision made impartially? There should be no evidence of bias or predisposition against the applicant. If there is an indication of bias, the decision should be reconsidered by another officer. Decision based on evidence. Was the decision made on the basis of evidence provided? If the refusal was not based on facts, or if evidence was misinterpreted, this will be a procedural fairness issue. Given the principles of natural justice and procedural fairness, reconsideration will be recommended if the applicant was not given a fair opportunity to present their case or provide additional evidence. The reasons for refusal were unclear or non-existent, not allowing the applicant to understand or contest the decision. There's any indication of bias or that the decision was not based on the evidence at hand. Recommendations for reconsideration. Reassessment of an application. The immigration officer should reassess the application with all the documents and evidence previously submitted, ensuring that the applicant's eligibility under Section 186W is correctly evaluated. Second, provision of detailed reasons. If the refusal is maintained, the officer must provide a detailed explanation of why the applicant does not meet the criteria under Section 186W, specifying which part of the regulation was not satisfied and why. Opportunity for response. The applicant should be given an opportunity to respond to any new or adverse findings before a final decision is made. Impartiality check. Ensure that the reassessment is done by an officer who has had no prior involvement with the case to guarantee an impartial review. The conclusion, the refusal of the post-graduation work permit under or the spousal open work permit under Section 186 Immigration and Refugee Protection Regulations should be reconsidered with adherence to principles of natural justice and procedural fairness. This includes providing the applicant with an opportunity to be heard, ensuring decisions are based on evidence, providing clear reasons for any refusal. And I want to conclude that I completely disagree with the actual situation of law enforcement very strictly apply on legal temporary residence in Canada. We should be focused in enforcing removal orders, deportation orders of people who are inside Canada, stateless or illegally, not law enforcement and severity on legal temporary residents who are the main investors of Canada right now. And we are all aware of this. Those are students. The severity applies to students and especially to those that are spouses, and working rights removal is something that I don't agree with. So we should reconsider the removal of working rights, and under any condition or any skill level, I don't agree with removing working rights. I had to experience that for years, being a spouse or a citizen, and I had my working rights not removed or partially removed for years due to a processing delay and a different condition of the spousal open work permit eligibility at that time. So my particular case was specifically that I had to wait for the approval in principle of my PR. So I had no option or eligibility to work, to have a work permit application submitted only until years after my application for PR, and I had no working rights, which was completely detrimental to the family, and is actually the removal of working rights and civil rights of temporary residents in Canada, especially those of spouses. I don't understand the reason. There's no logic to reapply this concept of conditioning spousal working rights. I completely disagree with it. So given the actual situation of Canada, we should reconsider and revert this nonsense decision to remove working rights partially and reimposing conditions for working rights of spouses. So this is everything for today. If you have any question or you need help with your reconsideration or your application, please use the links below the video and book a consultation. Thank you very much for listening. Give me a like and subscribe to the channel. Bye-bye.